All right, I do see, so Ms. Gibson, you did respond. And the last hearing I was at, I do note Ms. Baldwin's correct that there was a request for this to be heard as quickly as possible. So that was set on to the 11th, and then it was continued to today, the 18th. So given that this was filed, looks like the 12th of, sorry, the 9th of June, and we're at the 18th of July, and this is the third date that we've had since this has been filed. We'll handle this today. All right, so Ms. Baldwin, go ahead.
Thank you. This is a very clear-cut matter of contempt. This is for failure to pay daycare fees as apportioned by the order of child support. That is a child support obligation. When the court looks back at the record, you'll find that the court largely adopted Ms. Gibson's proposed statements about her income level and her proposed proportional share of the children's expenses. At that time, and throughout the case, essentially until this contempt was filed, Ms. Gibson repeatedly told the court that she could afford to pay all of her obligations so that she could avoid having the house ordered to be sold. Again, and it wasn't just that she could meet all of her obligations, she could meet those obligations and refinance the house in order to be able to avoid it being sold. So she said that she could refinance and increase what she was paying. This is what she told the court she was able to do. Now she comes before the court and says, oh, I can't pay it all. Let me make $50 a month payments, even though the obligation is somewhere in the hundreds and hundreds of dollars. Let me just pay $50 and not pay anything more. So which is it? You can't have it both ways in essentially a 6-month period of time. Either you can make all your obligations or you can't. And the reality is that Ms. Gibson will tell you whatever she thinks is going to get for what she wants on that day. I think it is notable that Ms. Gibson previously had a second job. She quit that job. That's a job that is not considered in her current income as set for the purposes of child support. So the court did not assess her to have that, but she did have that historically. Again, it's undisputed. There's a court order for her to pay that my client kindly sent her the billings, and that she, for the vast majority of it, has not paid. Her claims that there are, I've made $50 good faith payments, that is not good faith. That is a please don't send me to jail, but it is absolutely I'll pay what I want, so I'll just keep paying $50 so that you don't throw me in jail. She's not providing her bank statements. She's not saying here's all the expenses I've cut out. Gee, I've cut my cable, my phone down to the bare minimum. I've cut this expense and that. There's none of that. It's sort of just, gee, I can't pay.